15% of your Social Security can be taken before it reaches your account. Not frozen, not held, taken. Redirected to a debt you may have forgotten exists, on a loan you may not have taken out for yourself, with no court order required and no judge involved. And the program that does this just restarted after being paused for 6 years. Here's the part I need you to hear before anything else, because this is where the last video went wrong, and I am not going to make the same mistake. This reaches retirement benefits. It reaches survivor benefits. It reaches disability insurance. If you draw a federal benefit of any kind except the needs-based program, this can touch you. I am not going to spend 5 minutes getting to that. It is the first thing I am saying. If you receive Social Security on your own work record, on a deceased spouse's record, or on a disability claim, stay. Now, before anybody panics, 2 versions of this are going around and both are wrong. The first says the government is about to start garnishing every retiree's check. That is not true. This only reaches people with a specific kind of defaulted federal debt, and I'm going to tell you exactly what kind. The second says this was tried and canceled and it is over. That is also not true. It was paused twice, and the program it was paused for launched on the 1st of July this year. The machinery is live. Here is the accurate version, and it is 3 things. 1. What this program actually is, who it reaches, and the one debt that triggers it that a great many people in this audience do not even think of as theirs. 2. What happens when it starts, how much they take, and the floor below which they cannot go, because that floor is lower than you think. 3. The 2 exits that are still open right now, one of them for as little as $5 a month, and the deadline that closes the faster one. And I'm going to end with one number from a government report that should genuinely trouble you. It is not about the debt. It is about where the people on the other end of it were living before anything was taken. My name is Kevin. I read the rules, so you do not have to. Every week I go looking for the thing that quietly decides what happens to your money, and I bring it here before it costs you anything. If that sounds useful, subscribe and turn on the bell, because one of the 2 exits in this video takes 10 months, and 10 months from today is past the point where it helps. Let me start with the debt, because it is not the one most people expect. Student loans. Federal student loans. And before you close this video because you never went to college, hold on for 30 seconds because the person this hits hardest is almost never the person who sat in the classroom. A very large number of the people affected are parents. They took out what is called a Parent Plus loan decades ago to help a child go to school. They signed the paperwork at a kitchen table or in a financial aid office or on a form their child brought home, and the money went to the school and the child went to class and the parent went back to work. And then life happened. The payments were difficult. They fell behind. 270 days of missed payments later, the loan went into default. And default on a federal student loan does not expire. There is no statute of limitations. A debt from 1996 is as collectible today as it was the year it defaulted. So a person who co-signed something 30 years ago for a child who graduated and moved on and may not even know the debt still exists can have 15% of their Social Security taken in 2026 over a piece of paper they forgot was in their name. That is who this is about. And there are roughly 452,000 people over the age of 62 in exactly that position right now. Now here's how it works. The mechanism is called the Treasury Offset Program. It is run by the Bureau of the Fiscal Service, which is the part of the Treasury Department that handles federal payments. When somebody owes a defaulted federal debt, the agency that holds the debt reports it to this program, and the program matches your Social Security number against every federal payment you are scheduled to receive. When it finds a match, it intercepts the payment before it reaches you, not after, before. Your deposit arrives smaller, and if you were not watching for it, the first you know is a number in your account that does not match what you expected. The program can take up to 15% of your total monthly benefit. And there is a floor. Your benefit cannot be reduced below $750 a month. So if your benefit is $1,000, 15% is $150, which would leave you $850, which is above the floor, so they take the full $150. But if your benefit is $800, 15% would be $120, which would leave you $680, which is below the floor, so they can only take $50. Now sit with those numbers for a moment against real life. $750 a month as a floor in 2026. That is the amount below which the federal government has decided it cannot reduce your income. and that amount has not been adjusted for inflation since it was set. You are supposed to be required to receive a notice before any offset begins. The law says at least 65 days. That notice is supposed to tell you the amount of the debt, explain your rights, and give you an opportunity to request a review. In practice, those notices go to the address on file with the agency that holds the debt, which for a loan taken out in the 90s may be an address you left 20 years ago. Let me tell you about Jessamine. Jessamine is 73. In 1997, she signed a form at a financial aid office so her daughter could finish the last 2 years of nursing school. The loan was around $12,000. Her daughter graduated, became a nurse, and has been working ever since. What Jessamine did not know is that the repayment was always in her name, not her daughter's, because that is how a Parent Plus loan works. The parent borrows, the parent owes. She made payments for a while, and then she did not, and nobody came after her. And the years went by, and she retired, and she assumed, the way a person does, that something that old and that quiet was simply over. It was not over. It was sitting in a database, accruing interest, waiting for the program to restart. She has not been garnished yet because the latest pause is still technically in effect while the new repayment system rolls out. But the machinery is live, the debt is reported, and her number is in the match file. When the pause lifts, and it will lift, her deposit will arrive one morning $140 lighter than it was the month before. And her daughter, the nurse, has no legal obligation to pay it. It is not her loan. It never was. That is the whole reason the Quiet Rules exists. Plain English, printed large enough to read without hunting for your glasses, on the things that quietly decide what happens to your money. Which debts can reach your benefit, what the notice looks like when it comes, and the 2 routes out that are available right now. So that nobody in your family discovers a 30-year-old piece of paper is still alive by watching their deposit shrink. It is at kevinexplains.shop. The link is in the description below and in the pinned comment at the top. And if you are watching this on a television right now, there is a code on the screen you can point your phone camera at. 7-day guarantee, always. If it does not hand you something you did not have before, you send it back. So here's a question worth sitting with. Do you actually know whether there is a federal student loan with your name on it, from any year, for any person, that you stopped paying? Now the timeline, because the stops and starts are confusing and a lot of people have the wrong picture. Federal student loan collections were paused in March of 2020 when the emergency began. Payments stopped, interest stopped. Nobody defaulted, and nobody was garnished. That pause was extended again and again and lasted years. In May of 2025, the Department of Education restarted collections, including the Offset Program. The backlash was immediate, and within weeks, in June of 2025, they paused Social Security garnishment specifically. No offsets had actually occurred. Then, in January of this year, the department paused all involuntary collections again, including wage garnishment and the Offset Program, while it rolled out a new repayment system. That new system, called the Repayment Assistance Plan, launched on the 1st of July this year. It replaces several older plans with a single option. Payments run between 1 and 10% of your income, with a minimum of $10 a month and forgiveness after 30 years. And here is the sentence that matters. With the new system in place, the legal and administrative basis for keeping the pause has dissolved. The department has not announced a firm restart date for Social Security offsets specifically, but the practical expectation among everybody who works in this area is that involuntary collections resume in the autumn. Notices rolling out over the following months. That is why October is in the title, not because there is a date circled on a government calendar that says October, because the window to act before this reaches you is measured in weeks rather than years, and once a garnishment begins, stopping it is a considerably harder and slower process than preventing it. Now, the 2 exits, because this is the useful part and I want to spend real time on it. There are 2 ways out of default, and they do different things and take different amounts of time. The first is called rehabilitation. You contact whoever holds the loan, which you can find on the government's student aid website, and you agree in writing to make 9 on-time monthly payments over a stretch of 10 months. The payment amount is based on your income. 15% of your discretionary income divided by 12, and for somebody living on Social Security with modest resources, that figure can be as low as $5 a month. $5 a month for 9 out of 10 months. That is the whole thing. If you make those 9 payments, the loan comes out of default, the default notation is removed from your credit report, and the offset program stops. Now the honest parts that matter. You can only rehabilitate each loan once. If you default again afterward, this route is permanently closed. Only voluntary payments count. Money taken through garnishment or through a tax refund offset does not count toward the 9, even though it is money out of your pocket. You have to make the payments separately, on top of whatever is being taken. And if garnishment has already started when you begin rehabilitation, it does not stop immediately. It continues until you have made 5 of the 9 payments. So a person who starts rehabilitation after the garnishment is already running has 5 months of double payment, the garnishment plus the voluntary amount. That is survivable at $5 a month, but it is the reason to start before the garnishment rather than after. The second exit is consolidation. You apply for a new loan that pays off the defaulted one, and the default ends. This is faster, often 4 to 8 weeks rather than 10 months. You can do it online, and once it is done, you can enroll in the new repayment plan and make income-based payments going forward. Now let me be specific about what the rehabilitation payments actually look like for somebody in this audience, because the number is what makes people act rather than panic. If your income is Social Security only and you have modest expenses, your discretionary income, as calculated by the formula, is often close to 0, and the minimum payment is $5. So the rehabilitation agreement arrives in the post saying your monthly payment is $5, due on a date, for 9 out of the next 10 months. You write a check for $5, or you make a payment online, or you call and pay over the telephone. Once a month, 9 times. And at the end of it, the loan comes out of default, the default notation is scrubbed from your credit report, and the program that was about to take $140 a month from your deposit stops. $5 against $140. That is the arithmetic, and it is real, and a staggering number of people never do it because nobody ever told them the number could be that small. And there is one more thing about the timing that I want to say clearly. Starting rehabilitation does not require you to be current on anything. You are in default. That is the whole point. You do not need to catch up first. You do not need to make a good faith payment beforehand. You call, you ask for a rehabilitation agreement, and they send you one. The process begins the day they receive your first payment under the agreement. The downsides of consolidation are real and worth naming. The default stays on your credit report, unlike rehabilitation, which removes it. And for loans consolidated after the end of June this year, the repayment options are narrower than they used to be. For Parent Plus loans specifically, the income-driven option may not be available through consolidation at all, which means the monthly payment could be higher than it would be under rehabilitation. So the decision between the two depends on your situation. If you have time and the garnishment has not started, rehabilitation is usually the stronger choice because it cleans your record and preserves your options. If you are already being garnished or about to be, consolidation is faster and stops the offset sooner. And there is a third thing that is not an exit from default but can reduce what is taken. You can request a hardship review. If the standard offset would cause genuine hardship, you contact the Department of Education's Default Resolution Group and ask them to reduce or eliminate the offset. You document your income, your expenses, and your situation, and they make a judgment. They have generally been willing to grant reductions on Social Security offsets, more so than on tax refund offsets. It does not get you out of default, and it does not stop the debt from existing. But it can bring the monthly hit down to something survivable while you work through one of the other two routes. Let me tell you about Eldon. Eldon is 68 and he spent 34 years driving a delivery truck. He never went to college. He does not have a degree. He does not owe a student loan. His wife does. She took out a loan in 2003, 23 years ago, for a program she started and did not finish after a family emergency pulled her home. The balance was modest. The interest was not. The loan defaulted in 2006 and has been sitting in a file ever since. His wife died 4 years ago. And here's the part that Eldon does not know yet. If the loan was a joint consolidation loan, a product that existed for a narrow period and was taken out by married couples together, the surviving spouse can be held responsible for the balance. And even if it was not joint, the offset program does not only reach the borrower, it reaches the borrower's federal payments. If his wife had been receiving Social Security before she died, and the loan was reported to the program, the offset would have reduced her benefit. And if Eldon switched onto a survivor benefit built on her record, the question of whether that debt follows the benefit is one that he has never had occasion to ask, and that nobody at any office has ever raised with him. I am not telling you that story to frighten you. I am telling it because the version of this that costs people money is almost never the version they expected. It is not a person who ran up debt carelessly. It is a widow, a parent, a co-signer, somebody whose name is on a piece of paper from a decade they barely remember, and the debt has been patient in a way that nothing else in their lives has been. That is precisely what this guide exists for. Not to make anybody an expert in federal debt collection, to put the one page that tells you whether a debt with your name on it is sitting in that system, and what to do about it in what order, in a place you can find it on the afternoon it matters. Same place, kevinexplains.shop, link in the description and in the pinned comment at the top, and the code on your screen if you are watching this on the television. 7-day guarantee, no argument. A man whose wife took a class 23 years ago and did not finish, and a debt that outlived her. Now, 4 things you should know that almost nobody covers, because this is the part that decides whether you handle this well or badly. First, your tax refund is at risk too, and there is no floor on that one. The offset program can take your entire federal tax refund, including the earned income credit and the child tax credit, with no $750 protection. So if you file a return expecting a refund, and there is a defaulted student loan in the system, the refund may simply not arrive. Second, private student loans cannot do any of this. Not the offset, not the garnishment, none of it. This is exclusively a federal student loan power. If somebody contacts you claiming your private loan can garnish your Social Security, that is not true. Third, find out whether you have a loan in default before anything else. Go to the government's student aid website and log in. It shows every federal student loan ever taken in your name, the balance, the status, and who services it. If you cannot log in, telephone them. That single step tells you whether any of this applies to you at all, and it takes 10 minutes. And fourth, if you think you might be affected and you do not know where to start, there is a free resource. Every state has a student loan ombudsman or a legal aid program that handles exactly this, and they are accustomed to working with older borrowers who are confused and frightened and holding a piece of paper from the 90s. They do not charge. They are not selling you anything. They exist for this. And a fifth thing that catches people who have already been through this once before. If you rehabilitated a loan years ago and then defaulted again, rehabilitation is no longer available to you. You used your one chance. Consolidation is your remaining exit, and it works. But you need to know that the income-driven repayment options after consolidation are narrower now than they were the last time you went through this, particularly for Parent Plus loans. So the monthly payment on the other side may be higher than what you remember, and that is worth understanding before you sign rather than after. And if you are not sure whether you have already used your rehabilitation, the student aid website shows it. Log in, look at the loan history, and it will tell you whether a rehabilitation was completed on that loan previously. That single piece of information determines which of the 2 routes is open to you. Now the scam, because it arrives within days of a video like this one. Somebody will telephone you or send you a message offering to resolve your student loan, clear your default, or protect your Social Security from garnishment for a fee. Sometimes a few $100s, sometimes a monthly charge. Every single thing they are offering to do is something you can do yourself, for free, through the government's own programs. Rehabilitation is free. Consolidation is free. The hardship request is free. There is no paid service that has access to anything you do not have access to yourself. And the information they need from you to supposedly help, your Social Security number, your loan account number, your date of birth, is the information they actually want. The service is the story. Your identity is the product. If that call comes, put the phone down. If you want help and would rather not do it alone, contact a legal aid program or your state's student loan ombudsman, both of which are free. Now let me give you my honest opinion, which is only that, and you are welcome to disagree with me in the comments. Here is the number I promised you at the start. In 2016, the Government Accountability Office, which is the nonpartisan investigative arm of Congress, published a report on this exact program. It found that Social Security offsets for defaulted student loans were pushing tens of thousands of senior Americans below the poverty line. Below the poverty line, not toward it, below it. The floor is $750 a month. The federal poverty line for a single person is currently above $12,000 a year, which is above $1,000 a month. So a person living on $880 a month in Social Security can have $130 taken, leaving them at $750, which is below the poverty line. And the program considers that an acceptable outcome because the floor was met. That is the design. It is not a bug or an error or somebody being cruel at a desk. It is a rule written numerically, applied automatically, and never updated to reflect what it costs to be alive. And the debt underneath it is, in a great many cases, not the borrower's education. It is a parent's signature on a child's future, from a time when $12,000 sounded like something a family could handle, signed at a desk by a person who is now 73 and has been on a fixed income for a decade. I do not think the government should ignore defaulted debt. Debt is real, and a system that never collects anything does not function. And I want to say that plainly because it would be cheap to pretend otherwise. My objection is narrower. When the collection tool is capable of pushing a person below the poverty line, and the floor has not been updated in decades, and there is no statute of limitations, so the debt never ages out, and the person on the other end frequently signed for somebody else's benefit, the instrument has outgrown the problem it was built to solve, and the people operating it are required to use it as written, which means the only people who can change it are the ones who wrote it. And there is a second thing worth saying about the design, because it connects to the pause itself. The program was stopped for 6 years. During that time, interest continued to accrue on defaulted loans. So a person who owed $12,000 in 2020 owes considerably more than $12,000 in 2026, and every dollar of that growth happened while the government's own decision prevented them from making payments through the normal channels. Some of those borrowers tried to pay during the pause and were told they could not. Some were told to wait. Some were told the debt would be addressed through a forgiveness program that was subsequently struck down by the courts. And now the same debt, larger than it was, is being collected from the same people, at the same percentage, through the same program, as though nothing happened in between. I am not arguing that debt should be canceled. That is a political question, and this is not a political channel. I am pointing out that a system which pauses collection for 6 years while continuing to charge interest, and then restarts collection at the higher figure, has produced a result that is difficult to describe as fair, regardless of where you sit on the underlying question. And there is a bill sitting in Congress right now, introduced 6 days ago, to prohibit this program from reaching Social Security benefits at all. Whether it passes is not something I can predict. That it was introduced tells you that this is contested, active, and not settled. And one more thing before the checklist, because I would be failing you if I left it out. If you are a surviving spouse and you switched onto a survivor benefit after your husband or wife died, and they had a defaulted student loan, you need to know whether that debt followed the benefit. In most cases, the debt belongs to the borrower and dies with them. But there are situations, particularly with older joint consolidation loans, where the surviving spouse can be held responsible. If you are in that position, do not guess. Telephone the student aid number and ask whether there is a loan in your name, in your spouse's name, or in both names jointly. If there is a joint loan, it did not end with your spouse, and you need to know that before a garnishment tells you. All right, here is your list. 5 things, and every one of them is something you can do this week. 1. Find out whether you have a federal student loan in default. Log into the student aid website or telephone them. This takes 10 minutes and it tells you whether any of the rest of this applies to you at all. 2. If you do, and you have not yet been garnished, start rehabilitation now. The payment can be as low as $5 a month, and the whole thing takes 10 months. Starting before a garnishment begins is dramatically better than starting after. 3. If the timeline is too tight for rehabilitation, look at consolidation. It is faster and can be done online. Understand that the default stays on your credit report, and that repayment options for Parent Plus loans are more limited after June of this year. 4. If you are already being garnished or are about to be, request a hardship reduction immediately. Document your income and expenses and contact the default resolution group. They can lower the amount while you work through one of the other exits. 5. Check your tax situation before filing season. If a defaulted loan is in the system, your refund is at risk with no floor at all. Adjusting your withholding so you do not overpay during the year and therefore have little or no refund to intercept is a legitimate and legal way to keep your money in your own hands. And if your own situation is tangled, if you are holding a notice or a smaller deposit and cannot work out what happened, write to me. The address is on your screen and in the description below, and I read every one that comes in. One last thing before you go. Jessamine signed a form in a financial aid office so her daughter could finish nursing school, and the debt has been sitting in a file for 29 years, waiting for a program to restart. And Eldon does not owe $1 to any school anywhere and may be carrying a debt that belonged to a wife who has been gone for 4 years. Neither of them did a careless thing. Neither of them borrowed recklessly. Both of them signed something in a decade when nobody mentioned that federal student loan debt does not expire. And both of them are going to find out what that means from a deposit that arrives lighter than it should. So go and check this week while the pause is still holding and there is still time to choose which exit to take. Find out what is in your name. Find out what is in your spouse's name. And if there is something there, start the rehabilitation before anybody has to take anything, because $5 a month for 10 months is not a hard road, and it is the only road that gets easier the earlier you walk it. I am Kevin. Thanks for watching. Do not forget to check the quiet rules at kevinexplains.shop.